The Chevron case was heard by the Supreme Court in the early 1980s and established that when an administrative agency was interpreting the laws from Congress, giving them power, administrative agencies were given deference, which means that if their interpretation of that law was reasonable, the courts would adhere to that. Based on their ability to interpret the laws giving them power broadly, the National Marine Fisheries Service interpreted one of their laws broadly and decided that fisheries companies had to pay for inspectors to be on their boats, which was not necessarily written in the law itself. The fisheries services sued about this, and it went all the way up to the Supreme Court. The Supreme Court decided that when the statute giving the agency power is questionable, it's the court system that decides what that law gives them power over, which means that deference to the agency interpretation is gone now, and the courts are going to decide. Because agencies are no longer given deference, that's going to let the court system decide the most reasonable interpretation of the law. So when Farm Bureau takes cases to the courts and tries to get regulations interpreted in a reasonable manner, the courts are going to look at the statute that gives them the power and decide what is most reasonable and what Congress intended for that rule. Based on this, agencies are going to be held more tightly to what power Congress actually intended for them to have, and it's going to shrink the administrative state and make sure the agencies are not going outside their boundaries of what Congress intended for them to do. This is likely going to decrease the amount of regulations that are put on farmers and ranchers and keep them within the boundaries set by Congress. With the Chevron case overturned, agencies are no longer given deference in the interpretation of laws giving them power, which means that if there's been an unreasonable interpretation by them, somebody can bring a case to the court system. That only goes back for the last 6 years of regulations put into place because of the statute of limitations. The Supreme Court recently also decided a case called Corner Post, which decided that the 6-year statute of limitations no longer starts when the agency makes the regulation, but now starts when the party is able to sue on that regulation. This means that with the 6-year statute of limitations just being changed in June, for the next 6 years we can go back and people can sue about things that were unreasonably interpreted by agencies, which is going to open the floodgates for lots of unreasonable interpretations. Farm Bureau will continue to look at regulations and the laws giving them power and make sure that those regulations are reasonably interpreted for farmers and ranchers and advocate for them.